Costin Cruz versus Darius Nellums.
Yes, Your Honor, this is Luke Kennedy for the defendants.
And
Right.
Tristan Gillespie for plaintiffs.
All right. So, Mr. Gillespie, when we were reviewing your documents, your your motion.
The case begins with immediate tension. The judge openly questions the validity of several legal citations filed by Attorney Gillespie, even suggesting they might be hallucinated. Right away, the courtroom feels the weight of possible misconduct. The judge doesn't hold back, hinting that this issue may even need to be reported to the state bar. What would you do if you were the judge here? Would you call it out immediately or give the lawyer another chance?
Some of the cases weren't making sense.
Oh, goodness. I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to...
I did, Your Honor, and that was something that I wanted to bring up today. So that's part of the reason why I didn't file a reply, is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And so, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name. And
neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Attorney Kennedy, representing the defense, steps in. Calm but firm, he supports the judge's concern and reveals he intentionally didn't file a reply because the citations simply didn't add up. Kennedy points out that the cases cited don't even exist in Georgia law. This isn't just a minor mistake. It's the foundation of the plaintiff's argument unraveling in real time.
Sure. I'm pulling it up right now, Judge. Bear with me one sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as the Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Hold on one second. I'm trying to actually pull up the case itself. Hold on. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193, 2008 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you have.
The judge digs deeper. Gillespie tries to defend himself, fumbling with his computer, claiming he pulled the case from a Georgia Court of Appeals ruling. But Kennedy isn't backing down. He's prepared, with receipts. He explains that the case Gillespie cited by name actually leads to a completely different ruling, unrelated to what was written in the brief. This is where the cracks really start to show. The credibility of one lawyer is on the line, and the judge knows it.
Had issues, and then maybe I can tell you where I did.
as far as the citations go?
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Rowland versus Say case, that 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company, I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my.
One by one, Kennedy dismantles the citations. Each so-called case either doesn't match the citation, has been overturned, or says the exact opposite of what Gillespie claimed. At this point, the defense has built a devastating narrative. Gillespie's filing wasn't just sloppy, it was potentially deceptive. Do you think this was carelessness or intentional misrepresentation?
My brief. And Your Honor, I would just also say the timing of the filing would kind of raise some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. And that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersions. I'm just telling you, so he's been suspended in Maryland, and part of that was for lack of candor.
Hold on, where is he?
It appears that he either dropped off the Zoom call or lost internet connection.
I got knocked out. I think I'm using too much of my computer's bandwidth or something.
Then an unexpected twist. Attorney Gillespie drops off the Zoom call. Was it really internet issues or just an untimely exit? The timing makes the tension even sharper. The courtroom pauses, but Kennedy keeps pressing his case. Small detail, big drama. In court, appearances matter, and this disappearance doesn't help Gillespie's credibility.
Right now.
So, Mr.
Please.
Gillespie, I'm a former staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess ChatGPT or whatever the legal version of the AI, research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've, resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a second-generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation. when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you.
The judge takes control, reflecting on the growing problem of lawyers relying on AI-generated legal work. She stresses the importance of reputation, noting that when attorneys try to juggle multiple jurisdictions, mistakes are inevitable. This isn't just about one filing, it's about the integrity of the profession. The warning is clear. Shortcuts in law can destroy careers.
A duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than I'm happy to provide additional briefing, copies of the cited cases, whatever.
I trust that Mr. Kennedy went to a law school, if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if two lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
Understood.
I need some kind of understanding of what we're dealing with.
Despite Gillespie's attempts to downplay the issue, the judge isn't convinced. She stresses that multiple attorneys and clerks couldn't validate the citations. Additional briefing won't fix a lack of credibility. The judge wants accountability, not excuses.
Okay. Well, very good then. Should we? How would you propose we proceed?
Mr. Kennedy, this is also your client's case. Talk to me.
Yeah, Your Honor, I was mulling kind of what to do about it and what to ask for. And again, some of the stuff is going to relate to the summary judgment motion, which is not necessarily before you at this point in time. I would at least ask for my client's fees to be reimbursed for having to be here and respond to the motion or the response brief itself, which I don't have that number right in front of me, but I'm happy to supply an affidavit of what that is. Beyond that, I'm not sure if I don't want plaintiff herself to be penalized. So I just want to put that out there. I don't think she should be penalized because I don't necessarily think she has anything to do with this necessarily. It is more.
Well, the brief would, as I understand the statutes, the brief would constitute direct contumacious behavior before the court, which would result in a contempt finding. I wouldn't have to do much extra because it was presented to the court, and the contumacious behavior is written in written form before the court. So I would definitely, always back myself up and look again at the statutes before I make a decision, especially on a contempt. But
Kennedy makes a formal request: reimbursement of attorney's fees for the wasted time responding to a flawed brief. Importantly, he stresses that the plaintiff, the client, shouldn't be punished for her lawyer's missteps. This is a professional move, showing Kennedy is focused on fairness, not revenge.
I do believe that in this case, sanctions are warranted, and especially attorney's fees. So go ahead and present your affidavit, and then we'll make a decision on what's to be granted. But Mr. Gillespie, I say this, and I've said this, like literally my family's replete with lawyers. My brother's a lawyer, my mama's a lawyer, my uncle's a lawyer, I'm a lawyer. The one thing that's been drilled into me my whole life is in the practice of law, it's the only thing you have is your good name. And when you're trying to do too much is when you usually risk losing that. And I get trying to practice in a lot of different areas and do a lot of different things, but it is hard to be excellent when you do that. And so I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And so there may be consequences.
The judge leans in on possible sanctions, even mentioning contempt of court. Her tone sharpens as she reflects on the only thing a lawyer truly has, their good name. She makes it clear that she may have to report this to the bar, setting the stage for serious professional consequences. Do you think the judge should report Gillespie? Or is ordering fees enough of a punishment? This hearing shows how quickly credibility can collapse in a courtroom. Attorney Gillespie's reliance on questionable citations and the possibility of AI-generated filings put his entire reputation at risk. Kennedy's steady dismantling of the citations highlighted the importance of preparation and integrity, and the judge's words drove home the ultimate lesson. In law, shortcuts may win you time, but they can cost you everything. If you found this case as eye-opening as we did, hit that like button. Share your thoughts in the comments. Who do you think was in the wrong here? And don't forget to subscribe for more real courtroom moments and expert breakdowns.